to be, I do not consent
Okay.
to be represented or binded by any assumed legal identity or straw man. I assert my full rights under natural law and constitutional protection as a sovereign individual. I stand before this court to represent myself. All legal matters pertaining to the charges brought against me. I reject any notion or claim that my person may be divided, operative.
And there it is. The judge immediately cuts in. That quick shutdown tells you everything. From a legal standpoint, the court isn't entertaining this argument at all. Instead, the judge is already thinking ahead. This is going to be a problem. Notice how fast this shifts from speech to control of the courtroom.
Or substituted by any separate legal entity. I affirm that all statements, evidence, and arguments I present are made on behalf of my living self.
Right from the first line, you can tell this isn't a normal defense. When someone starts by separating themselves from their legal identity, it usually means one thing, a strategy that almost never works in real courtrooms. So the question is, does he know that?
Fully understanding my rights and responsibilities as a free individual.
Hey, you finished? All right, the court on its own motion is going to adjourn this because we're going to have an issue here. I have a feeling. I'm going to adjourn this probable cause hearing next week, August 7th, 2025. That's at 9 a.m. That is in person. He must be here so that I can hear him clearly in terms of what he wishes to say. Bond at this time will continue. Thank you.
I'll follow up with you. Thank you.
They did have my Social Security backwards and everything. Had me at the wrong birthday. I was born on Christmas, 12/25/66.
If you ever told that for people.
Your Honor, we're requesting to adjourn this matter.
State your name for the record, sir.
Red Kraken. I haven't had any income or nothing. They shut down. I didn't put my name at this. I didn't put my birthday.
Hang on a second, sir. Have you ever gone by the name of Stephen Javon?
Here's the legal reality. Courts don't operate on personal beliefs. You can claim you're separate from your legal identity, but legally, that identity is exactly what the court has authority over. That gap between belief and law, that's where most of these arguments collapse.
Yeah, they had me listed at that name. That's my.
They had that listed as your name, but you're saying your name is something different now?
They had me listed at that name. I didn't know. I woke up from what they were doing to me. I had attempts to kill me, man. I hadn't had a night's sleep or nothing. Right now, my health is down, man. I'm suffering from a gunshot wound from segregation, in which I'm still going through stuff. I left a hospital with open wounds. Something happened.
Okay, but I just
not
need
too
to
long
know.
ago. And then you were part of something. I'm really excited conflict of interest with this. I'm really just deciding to kill this case, man. Because this case is, they got me the last day of the art fair. The last day of the art fair, I'm asking you to kill the case.
What art fair?
That's what happened to me. They made a false report. They got me.
Okay, all right.
This stuff, crazy
Hold on,
stuff.
hold on. At some point, I myself or some other judge will hear all of your complaints. I just need to know, do I have the person in front of me that this complaint pertains to? So that's why I'm asking you. You've been known by the name Stephen Javon before at some point, correct?
Yeah.
Okay. All right. Counsel, what do you want to do on this?
Don't you approach, please.
No.
Maybe
I'll keep
approach.
going because I ain't had no income. I can't keep going that stuff with it. Just doing stuff to me. I've had
Is this going to be important? It's okay. Yeah, come on.
This is an open and shut state. I shouldn't be.
All right.
Notice what's happening here. Long statements, complex wording, but no direct legal defense to the actual charges. In court, clarity wins. And right now, the judge is already losing patience.
Go ahead. Okay, what are we, record to reflect, you had a brief bench conference in this case. What are we doing with this man?
Your Honor, the people would like
This is the turning point right here. When a competency evaluation is requested, it means the court is questioning whether the defendant fully understands the proceedings or can assist in their own defense. That's serious. And his reaction? It only escalates the situation. Now, ask yourself, does this behavior help his case or completely damage it?
To request that there is an order for a competency evaluation, that is on a people's motion. I think that given what we've just heard from the defendant, it's an appropriate request at this time.
Any evaluation, and they almost killed me. Man,
Sir,
let's get me out this
sir,
room, man.
sir,
Almost killed
sir,
me, man.
sir,
I can't
sir.
keep going through this, man.
Sir,
I'm not gonna go
Sir.
through no evaluation because I got an education, man. I'm not going through that no more.
Sir.
You did this last time to me, man. It's already a conflict of interest. I don't even yeah. I'm just saying.
I'm gonna say,
he got
sir, I'm gonna say,
something now.
sir, one
I
more
had a
time.
Reaction to that,
Sir,
almost was dead from that allergic reaction.
This is a classic courtroom power move. When a judge cuts you off, it's not personal, it's control. They're steering the case back to what actually matters legally. And once that happens, you're already on the back foot.
You and Collins, man. Already a conflict of interest.
I'm gonna order a competency evaluation, parental
I'm ordering you
evaluation.
for a competency evaluation, man. Pretty,
Yeah.
I'm finna sue y'all, man.
You wanna know
I leave
what?
here.
You keep talking, we're gonna have a problem.
I'm
I'm
not
gonna
getting no
get- I'm
evaluation
gonna
from
get
you.
through-
You're not gonna do
I'm
this to
gonna
me
get
again.
through this hearing,
Yeah.
all right?
Not
If
gonna-
you don't wanna conduct yourself appropriately, then we'll sit you in back until you can come out and conduct yourself appropriately.
I ain't going to no competency evaluation. I don't need no competency. I had medication I shouldn't even have in me. Almost
I'm gonna
died,
let you
man.
go
I'm
on
not
and
gonna
try to get it
I'm
all
not gonna
out.
be under no pressure with no medication. I'm not gonna be taking something that I'm not.
All right, I'll tell you what I'm gonna do. I've given you 2 warnings. I'm gonna pass the matter. Mr. Allen, you can place him in back. I will decide on what his bond is and everything else. You need to go with my bailiff, sir.
Man, you sitting there. I'm finna
You
get
need
you
to
in trouble.
go with them. Call security down.
Courtroom the same way, but man, you that's what the same way you a part of something that did something to me, man. All the time.
You guys might want to go check back there. That I don't know what's gonna happen. Okay.
That's his
What?
backpack.
What about his backpack?
Oh, it's your backpack? Oh, I was like,
You can take it home with you. I'm not, well, they'll get it.
yeah.
Just leave it there. I am not worried about that backpack. I'll pass this matter and we'll come back to it,
Thank you.
maybe.
That adjournment isn't random. The judge is hitting pause because something feels off, whether confusion, behavior, or understanding. The court is now preparing for a bigger issue than just the charges.
But that was the first test, and since then, he has been clean.
I don't know how you say that. He took one other test
Yes,
and then didn't test.
yes.
That's,
He will spend $150 in test at a private
could
clinic.
have done that
Yes,
before.
absolutely.
That- Court does call the case People versus Randall Jolly.
Judge Mark Ellis representing Randall Jolly. Sir, please tell the judge your name.
Randall Jolly?
Your Honor, this is a PCC. We're requesting an adjournment of that, but as the court is reviewing, we have a bond violation.
Yes.
May I address the bond violation? Your
Yes,
Honor?
please.
Your Honor, I was not the lawyer on the record at the time that the arraignment was happening, so I wasn't there, didn't know about it. I did review it this morning. The bond document in the file does not order my client to be subjected to testing. It tells them don't do drugs. Now, I don't plan to use that.
Well, but counsel, go ahead, you can.
I don't plan to use that as my
want, but he's, go ahead.
Not a problem. Judge, the problem is really the past and going forward. He tested positive for a drug which is a opioid inhibitor. That, of course, is a drug you cannot get and you cannot take if you are taking opioids because the combination of the two is likely to kill you. He has a prescription for that. So the funny sounding buprenorphine, yes, he has a prescription for that. He today can pull out of his pocket a copy of a...
Now things take a serious turn. We've moved away from legal arguments into personal claims and distress. And in court, that raises a major question. Does the defendant fully understand what's happening?
His pill bottle showing his prescription.
No, he told about grabbing it out.
So, Judge, I have that available to the court.
He's on Suboxone.
He is.
Okay.
Yes, Judge.
Can I say?
No.
But you're saying he didn't know that he had the test?
No. That is not my argument. But Judge, going forward, I believe there's a problem. He has missed the last two tests. The only reason he missed the last two tests is he is employed full-time at Ford Motor Company. He has his employee badge in his pocket. If you can pull that out, we will offer that to the court. He works a crazy schedule. He builds cars, and he starts at 6 a.m. and he gets out at 5 o'clock at night. His testing facility closes at 4 o'clock at night. He's been there 5 years, but he doesn't have the sort of seniority to grant flexibility. So we apologize for missing it. So this morning, when I had no idea that there would be a bond.
What was the other drug, the amphetamine?
That was the initial time, Judge, and he's absolutely guilty of that. That was the first time he was ordered to test. Yes. Since then, he has not taken any of that stuff, and he will test negative today.
Well, there are two things. One, he had THC in his system.
Yes.
Whether he took it or not, he doesn't get a card till the next issued the next day.
Yes.
He also has abnormal creatinine, which is a problem because that usually will appear in rare circumstances, but typically when somebody's trying to mask.
So Judge, if I may, he absolutely flunked your first test, no question about it. But that was the first test, and since then, he has been clean. He missed the two tests.
I don't know how you say that. He took one other test.
Yes.
And then didn't test.
Yes.
That's...
Your Honor, may I say something? I'm sorry to interrupt.
This is a turning point. A competency evaluation changes everything. It's no longer about guilt or innocence. It's about whether the defendant can even participate in the trial. Without that, the case can't move forward.
I just wanted to say something on my behalf.
Go ahead.
I live in Wayland. I work in Wayne. It's a 2-hour drive. I drive literally 4 hours a day back and forth to go to work and get back home. I work till 5 o'clock. I called my probation officer. I want to test. It's not that I'm trying to get away from testing. It's impossible when it's at a time I can't get there. And I don't want to lose my job because that's some benefits for the kids. I mean, it's a rock in a hard place situation. And I'm just trying to figure out the best way to move forward without losing.
Did you talk to your attorney about testing closer to where you are?
No, Judge. I had no idea there was a problem. But I will say this. When I found out this morning there was a problem, I called testing facilities. Yes. And I found places that have more relaxed hours. They also charge $130 to $150 for a test. At the moment, your court's charging them $12. And I mean,
I don't mind paying the money. And it's the facility closed at 4. I just get off at 5. I have no issue testing, Your Honor. I really don't.
Well, when I look at this, you sit up here telling me you don't have an issue testing. I've got 2 missed tests.
Correct. I have an issue because of the time, Your Honor. That's it. I'm hands down. It's just because of the time. And I'm not trying to skate. It's hard. It really is hard to get out of my job. It's an assembly line, so they can.
I understand how.
I want to fix this. I do. I really do.
Well, and I don't know why somebody's not contacting the court or somebody prior to us getting to this point today. And when you know you haven't tested.
Sorry, Judge, I read the email this morning. I had no idea there was a problem.
And it would be one thing if all that was showing up in the system is Suboxone, but that's not everything that's showing up in the system from the initial test. And then I really don't have much for August.
I'm sorry, I didn't.
I don't have testing for August. I mean,
Yes.
effectively, I don't have it. The whole month. He doesn't test.
I want to, Your Honor, I do. I just need a facility that's a little later. I'm just scared to lose my job. It's really.
And here's the problem. Resisting a competency evaluation usually backfires instead of helping your case. It often confirms the court's concerns.
I got my kids. I mean, it's just hard.
Judge, had I known, I would have made efforts to try to resolve this before today. I had no idea this was coming
I
up.
just need a little help.
Any response from the people?
Your Honor, I'm trying to sort it out. My concern stems from the fact that this offense date was July 2nd of 2024, where the defendant was arrested in possession of 56 pills of Adderall, which will show up in his system as amphetamine. And when he was arraigned just this past month, he's given the opportunity to test to show that he was clean, and it shows that a year later he had methamphetamine in his system. Granted, it was right after he was released from custody, but without the ongoing testing, there's really no way to ensure the safety of himself or the public traveling back and forth so much on our roadways. If he's not clean, I have the same concerns that the court does, but can't add anything additional.
Anything else?
Judge, I wish there was an easy answer.
Your Honor.
If the court allows, he will spend $150 in test at a private clinic.
Could have done that before.
Yes, absolutely.
That's my point.
You're
My
exactly
point
right.
is he could have done that before.
Yes.
There is nothing that prohibits him from doing that. What I have and what the prosecutors added is that the only test I have is that same drug that's showing up a year past is still showing up in his system. And then I don't have any testing. Simple as that.
You don't.
If it shows one, I really did. My probation officer, what she'll tell you. Sorry, here, sorry.
Court test him today.
I can't get them in because of time.
Well, we said by 4:30. Oh, sorry. Sorry. Yeah, I'm sorry.
And find out if they can test him right now. If you come back dirty,
I won't.
I am putting you.
I have not taken none, I swear.
You know what? You need to be quiet about now. Can you see if they can get him tested?
Yeah.
At this stage, the case isn't about arguments anymore. It's about control. Once things spiral like this, judges move fast, decisions get stricter, and outcomes rarely go in the defendant's favor. So what do you think? Strategy gone wrong or a complete breakdown in real time?
He will test positive for the opioid blocker. Prescription, he takes it.
I understand that. Counselor, you probably should stop talking too.
I'm not good at that skill, Your Honor.
I know. No answer yet. You need to go over there and see if you can test You don't get tested, you're gonna go.
So, Your Honor, may he take a sick day and test tomorrow morning first thing?
No,
Okay, thank you, Judge.
I gave you your options. Go over there and test. If they let you in, fine. If not, you still gotta come back here.
Sure.
And if you don't test, you're going.
Thank you, Judge.
Bye.
Thank you, Your Honor.
Really? No, I'm kidding. You're welcome. He calls the case of the people versus Randall Jolly.
Pretty good. Sure, maybe for the people in Your Honor.
Your Honor, Mark Ellis representing Randall Jolly. Mr. Jolly, tell the judge your name.
Randall Jolly. First thing that I'll do is I will adjourn the probable cause conference to the 18th, 2025, 9 o'clock. His test came back. He's positive for the marijuana. He did get a medical marijuana card the day after he first tested positive for marijuana. I'm going to suggest that you probably start or cease using that. But I have negatives on everything else. So what I will do is I'll continue his bond at this point with the admonition that if you miss another test, I'm not hearing argument, you're going. Simple. And then the other portion of that is that I will allow defendant may test What county is that? If you live in
Allegan. Allegan.
I'm a Michigan resident.
I'm sorry.
He may test in Allegan County at an approved facility by Community Corrections.
I apologize, Your Honor. May I have the PCC date one more time?
Is the 18th.
Your Honor,
his test results, he must sign a release so that his test results are sent to Community Corrections.
Your Honor, if I may, first of all, thank you. I appreciate it. My condolences on this docket of yours today. Judge, in the interim, my client contacted his boss at work. It is possible that he can test at the Ford Motor Company. Evidently, they have those facilities in some way. If that can be arranged, is that good enough?
That if as long as Community Corrections will approve the testing and the manner of testing, I'm not so concerned. But those results must be released to Community Corrections so that they can be reported to the court. So he'll have to execute the necessary releases.
I'd be happy to do that. Do we have any idea who I would contact at Community Corrections?
I do not. So what I suggest is you call over there, indicate his name.
Yep, very good. Thank you, Your Honor. Have a good afternoon.